Having considered the material on record and submissions advanced by learned counsel for parties, it is apparent that the transfer application has been filed before the consolidation commissioner by the opposite party number 3, although the transfer application does not indicate that it has been filed in the capacity of the manager of the institution, that is, opposite party number 4 star. The petitioner has thereafter filed a short counter affidavit indicating preliminary objection regarding maintainability of the transfer application and had subsequently filed his objections to the transfer application itself, in which a plea has been taken that the allegations made against the presiding officer are completely false and uncalled for staff. A perusal of the impugned order makes it evident that although a preliminary objection and the objection on facts of the transfer application have been noticed by the consolidation commissioner, but without adverting to the same, the impugned order has been passed transferring the appeal only on the ground of apprehension on the part of the transfer applicant opposite party number 3 staff para. Since, the consolidation commissioner has not recorded any finding with regard to the preliminary objection about maintainability of the transfer application in terms of the Rule 65 of the rules, it would not be appropriate for this court to deal with the said issue, and the aforesaid question is therefore, left open staff para. The matter pertaining to transfer of case from one court to another merely on the basis of allegations made in the transfer application without verifying the allegations made against the presiding officer cannot be permitted in such a casual manner. In case transfer of cases is allowed in such a manner, there can never be any finality attached to any litigation, since upon any inconvenient question being asked by the court regarding the litigation, any party to dispute would seek transfer of the case, and for not having to answer such inconvenient questions, it is quite correct that seeking transfer of any case from one court to another while casting aspersion on the integrity and character of the presiding officer cannot be taken lightly and has to be considered in a serious manner. As such, any such aspersion on the integrity and character of the presiding officer while seeking transfer from his court has to be treated with utmost seriousness and concern by the authority hearing the transfer application. The transfer application at the behest of any of the parties to the list be done only after the apprehensions and allegations indicated in the transfer application are verified by the authority or the court hearing the transfer application. It is not to be allowed in a routine manner. Para. So far as the transfer of the case in terms of the averments made in the transfer application is concerned, this court in the case of Kedar versus Additional Commissioner, UP, Lucknow and others, 2003 under bracket 94 RD 430 2003 under bracket 2 AWC 866 has clearly stipulated that transfer of a case from one court to another is a very serious matter, as it casts a doubt on the integrity of a presiding officer. It has been held that the court must be very conscious in dealing with these matters.